Welcome back to our workshop on divorce, separation, and family law. Today we're going to be talking about child support. In North Carolina, child support is determined using the Uniform Income Shares model. The Chief District Court judges from all over the state get together once every 3 to 4 years and set a formula for determining child support. This formula works on two different worksheets, Worksheet A and Worksheet B. With Worksheet A, if you have primary custody, defined as having the child more than 242 overnights a year, such that the other party has less than 123 overnights, then you're on Worksheet A. If the visitation parent has more than 123 overnights, then you're on Worksheet B. There are also provisions for Worksheet C. That's complicated. We're not going to talk about it today. Nearly 70 to 80% of people fall under Worksheet A, and if they don't, they usually fall under Worksheet B. We at Rice Family Law have even created a nice iPhone app that you can download from the Apple Store. And if you do so, it works for Worksheet A. You can just run the calculation right on your iPhone. It'll tell you what the child support obligation would be that either you have to pay or money that you'll receive. And that'll help you budget when you're making a plan to separate from your spouse. Let's talk a little bit about documentation. Again, our 9 steps to divorce tell you exactly what you need to collect. But when you go into court, we're going to need your most recent pay stubs, we're going to need an employer certification of wage affidavit, we're going to need a child support affidavit, and we can provide all of this to you. In fact, if you look to your right of this video, there are links to download those documents and you can go ahead and prepare them and get them filled out. There are reasons in North Carolina you might want to deviate from the formula. It's called a deviation from the North Carolina Child Support Guidelines. Often when we represent a father, we're going to file a motion to deviate because we want the court to consider the actual needs of the child and not just the needs that are determined pursuant to the formula, because we want to make sure that the child's needs are met, but we also want to make sure that nobody's overpaying child support. How does a court determine the amount of child support that it will award?
Well, essentially what you do, or what the court does, is it takes the gross income of both parents. It adds those together to come up with a figure to use in comparison with a worksheet that the state provides. The worksheet has how many children versus their gross income, and it determines what the state has decided it takes to raise a child based on those incomes. You take that, and that's the child support obligation for those two parents. You decide which one pays how much depending on who has primary custody of the child and what their percentage of each person's income is that makes up the total.
You really need to get a court order awarding child support. This is important because while the parties can enter a contract providing for an amount of child support, the enforcement remedies are limited. If the non-custodial parent is not paying under a child support court order, the court can take drastic remedies, including putting them in jail. And that will get their attention, and typically they'll pay. What information should a person gather for a child support hearing?
For a child support hearing, they should have a worksheet detailing their monthly expenses. They should have their pay stubs, their last year's taxes at a minimum. They should have anything that shows where any other income is coming from. If they do odd jobs, checks that have been cashed as payment for those odd jobs, etc., etc. And any child care receipts.
In certain instances, if you've already separated, You can file for retroactive child support for up to 3 years. And in your child support court order, you also want to make sure that you describe the percentage that's paid for unreimbursed medical expenses. Each party should at least be responsible for 50%. Let me tell you, when your 14-year-old daughter goes and gets $5,000 braces, it's nice if the other side's obligated to pay a percentage. Also, with child support, many married couples, as they're getting divorced, want to talk about and plan for college. A court cannot order the parties to pay for college because child support terminates once the child is 18 or graduates from high school. In fact, child support can extend up to age 20 under certain circumstances, but it can't provide for college. However, the parties can voluntarily agree to be responsible for college expenses, and we can help you put that in writing so that it's enforceable when the time comes. I've enjoyed the opportunity to share some information with you today about child support, and I look forward to seeing you tomorrow when we're going to talk about post-separation support and alimony.